Good morning, Jennifer.
Good morning, John.
We're here with Jennifer Hatch from Jennifer Hatch Law. And Jennifer, I want to thank you for joining us this morning.
Thank you for having me.
Great. I'll read your bio and ask you a few questions.
Sounds good.
Okay. So Jennifer's practice concentrates in family law with a specialty in a non-adversarial divorces. Although Jennifer is an experienced litigator, she now focuses her family law practice on collaborative family law and mediation. These non-adversarial dispute resolution options empower families to resolve disputes without the trauma that litigation can exacerbate. So, collaborative family law, I've been hearing more and more of that. So what is that approach, the collaborative?
So the collaborative approach focuses on forming a team around both spouses. So each spouse has an attorney. There's a coach whose underlying profession is usually a mediator, sometimes a therapist. However, they don't provide therapy to the clients. Rather, they're there to manage the process. I think of them like case managers or project managers. And the reason why they usually have a background in mediation or therapy is because they need to understand the emotions in the room and manage the emotions of the clients and how that impacts their judgment and decision making, as well as the attorneys, so that the attorneys don't fall back into an adversarial mindset. And how even sometimes emotions might affect, what an attorney does during a meeting. As best we try, sometimes attorneys can let emotions take control of their behaviors as well. So the next part of the team is a financial advisor in many cases, not all, but in many. And that individual acts as a neutral, where they provide information on the financial picture of the family and how to divide the assets and provide support so that both sides of the family can move forward independently and separately. And then the last part of this structure, this team, is that everybody signs an agreement that they're not going to take this matter to court. They're not going to litigate. So that eliminates that risk of like, well, I don't like how this is going, so I'm just going to, file in court and take this to court if you're not doing what I want you to do or agreeing with me. It really places the pressure on the parties to dig deep and find a resolution to the problem. Now, of course, there's no consequence if you decide to leave the collaborative process. I mean, some parties do, but for the most part, people enter it with the desire to solve the restructuring of the family, and work together outside of the court. And so they commit themselves to that.
Okay, now how would someone even think to reach out to this approach?
So there are actually a lot of attorneys in Massachusetts that are trained in collaborative law. So it's really incumbent upon the attorney to explain this process to the client when they call, and present it as an option. I also think when you're looking for an attorney, when you're in the client shoes and you're looking for an attorney, you want to look on the website for something that indicates they are trained in collaborative law. There are attorneys, I do mention that there are a lot of attorneys out there that are trained, but for those who are not, they might say, oh, sure, yeah, I can work amicably, I can work collaboratively, that's fine, no problem, we can resolve this outside of court. But the collaborative process is really a paradigm shift, where you advocate for your client's interests, but the focus is not adversarial, the focus is on problem solving. So without that training, if the attorney is not trained, they really don't have that shift in thinking, that paradigm shift. And inevitably, cases often fall into the adversarial process.
Okay, so
if the attorney is not collaboratively trained.
Right. I would imagine that if someone were to go down this path, right, when you first meet with them, you probably want to ask both parties, there is life after divorce. What do you want it to look like? What's your
Right. Yeah, exactly.
So I think that I would like to think that would keep folks focused on the end goal, because there might be some little bumps along the way, but as long as they're still looking at the vision, it
Yeah.
might make it a lot easier to keep moving this thing along.
Yeah, and I think also when you participate in the collaborative process, both parties have to buy into it. Unfortunately, sometimes I have clients who want to do it, and I send a letter to the other spouse proposing the idea, and then I provide collaboratively trained attorneys, the names of collaboratively trained attorneys in my letter, and as well as reference to the website, the Massachusetts Collaborative Law Council website, to encourage that person to look into it. Sometimes they do, but sometimes they don't. They just have a picture in their mind as to how the divorce process is supposed to be, and they are not interested in the collaborative process, which is unfortunate. But I do find that my collaborative training allows me to approach cases in a better way than if I didn't have it. So I can take the tension or the tone or the tenor of the case down a little bit when people start to get fired up. My mediation and my collaborative law training allows me not to inflame sometimes tense situations and maybe bring everybody down a bit and approach it a different way. The other thing that you mentioned about looking ahead and what does your life want to look like, the other thing that I do is I'm Consilium trained, and Consilium is a new perspective on how attorneys should practice in family law. And one of the focuses in the Consilium process is to empower and encourage the client to look at their future. Like you mentioned, how do I want my future to look? And then how do we shape the separation agreement around that, instead of keeping your focus on what you want out of the divorce.
Okay, and how do you move it along without having one of the other parties feel that you're favoring the other spouse or whatever? I'm sure that.
Oh, in the collaborative process, you mean?
Yeah, like I imagine. Oh, I'm sorry. Go ahead.
No, go ahead. What were you gonna say?
No, because I would imagine that it's tough to be 100% of the times 50-50, at least in the client's eyes. You might be happen to speak to one spouse a little more than the other, just not intentionally, just might have maybe that's the way the conversation's going, and the other one's probably saying, oh, she's favoring you over me or whatever.
Yeah. So actually that's a risk, I think, in either mediation or the collaborative process. So when I act as a mediator, mediator is supposed to be neutral, just like in the collaborative. Well, in the collaborative process, the attorneys aren't neutral. I mean, they are advocating for their clients' interests, but they're also looking at it from a big picture perspective. The two attorneys are looking to solve and restructure their family so that both people aren't harmed. So the difference is, in mediation, the mediator is a neutral, and I'm supposed to focus on drawing out the interests of the people in front of me. Like, what is their interests? What is driving them to say what they are saying or propose the ideas that they're proposing? Because if the parties understand their own as well as the other's interests, it helps them, instead of positions. Interests is why you're doing something, as opposed to position is I want this.
Right.
So once people start to understand the interests of themselves and the other people, it allows them to problem solve more easily. And so that's true. There is a risk where one client might sort of perceive me in a mediation setting to be favoring one spouse more than the other. But this comes down to the skill of the mediator. What I try to do is be mindful of my own biases, and then use curiosity to redirect the conversation, as well as keep my mind open. So I ask a lot of questions, and sometimes clients will go home from a mediation session with homework. They'll present a question, and it's not my job always to answer it, but I might say to them, well, how are you going to figure that out? And they'll say, well, I'll ask my attorney or I'll ask my accountant. or I'll call human resources at my company. Okay, great. Well, that's the homework. So in a collaborative process, what the attorneys are trained to do, which is very different from the adversarial process, is to actually engage the other spouse. So if I'm sitting in a room with the other attorney opposite me and the non-client spouse opposite me, and then my client sitting next to me, if you are in litigation, you're really not supposed to talk to that other spouse. But in the collaborative process, I actually can engage that other spouse and get to know them and learn about who they are.
Okay.
And I prepare my own client for that, because that's part of the collaborative process, is to understand both sides, so that when I'm advocating for your interests, I'm also sort of aware of what the other side is interested in. And that keeps you from being singularly focused on just what your client wants, but it keeps you on the big picture, going back to what you were saying, like how is their life going to be as co-parents? What is the future going to look like, not only for my client, but for both of them?
All right, awesome. So when someone's researching all this, like what would you say that they should be looking for, whether it's when they start interviewing different folks?
Yeah, they should definitely, first when they look at first, if they're just looking at the processes, the collaborative process and the mediation process, they want to go to the Massachusetts Collaborative Law, MCLC, Massachusetts Collaborative Law Council website, MCLC. They can also go to the Massachusetts MCFM, Massachusetts Council of Family Mediators, MCFM, to learn about both processes. And in terms of when you're looking at an attorney, well, first, both of those websites actually do list mediators and attorneys. But when you're also looking at a website for a lawyer or a law firm, you can tell by the language that they use. First, you want to see if they've been trained in the collaborative process through MCLC and or trained as a mediator. And there's lots of organizations in Massachusetts that train mediators, so it doesn't have to be MCFM, it can be another one. And then you also want to look at the actual language that the attorney uses. So, for example, I just looked on the website of an attorney yesterday, and the language on the website was, "I'm a litigator. I assume all cases go to trial." Unfortunately, more cases go to trial these days than settle. So even if you want to make sure that your attorney, when you choose an attorney, you want to make sure that your attorney is not afraid of trial. You have to walk into the situation assuming you have to try a case and that your client is and your attorney is prepared. If you settle, great. But that's how this website was designed. And I mean, that's an extreme, but there actually are a lot of websites and biographies that are written in more subtle but similar ways. And that doesn't make that attorney a bad attorney. It's just if that's what you want, then great, you go for that attorney. But that attorney is going to approach the case, perhaps just as skilled as a dispute resolution attorney, but they're going to approach it with a different goal.
Right.
And I've had attorneys like that. I've been opposite attorneys where there's no settlement, there's no compromise, there's no moving these parties towards a more peaceful future. It's their goal is solely to get what their client wants, and they do anything and everything to accomplish that. And that's a different type of advocacy, and that's great. And there's very successful and good lawyers who do that. But if that's not what you want, then you need to look at how that attorney describes their approach. And you need to ask them, when you're talking to the attorney, if you get bombarded with angry emails from the other attorney, how are you going to respond to those? Because that drives up fees, and that instigates and inflames problems. So you need to ask your attorney how they're going to respond to instigating behavior. How do they see the case? How do they advocate for you? How do they approach cases? How do they approach their own clients? there's also, that's also important. I tell my clients right up front, I expect you to be a shining star. If you need to produce some discovery, if you need to
Right.
abide by a court order, I expect you to do those things, because if we do ever end up in front of a judge, which sometimes we do, you've done everything right. You are the beacon. You have the credibility for the judge. So when I speak, they're going to listen, and that benefits you in the end.
That's great advice, actually. I always say that too on my end. My favorite client is the one that listens to me.
Because why do you hire?
Well, that's it. That's it. So how would someone get a hold of you if they needed your services?
Yeah, so my website is jhatchlaw.com, and my email is jennifer@jhatchlaw.com, right? jhatchlaw.com is my website, and jennifer@jhatchlaw.com is my email. And I'm also on LinkedIn, and you can also call me at 339-204-6888.
Oh, that's great. You've given us a lot of great information. Do you have a final thought you'd like to leave with us today?
No, it's just been a pleasure to know you, John. I really like your approach to lending and problem solving. I really see divorce as restructuring a family, and how can we do that so you feel better about your future, despite the stress of separating from your spouse.
Oh, that's great. Well, Jennifer, this has been a pleasure, definitely. And we'll listen, have a wonderful day, and we'll catch up soon.
Yeah, you too. All right, bye, John.
All right, we'll see you.